The second important question relating to this series, in particularly in connection with industrial and labor legislations, is the West Bengal State Electricity Board vs. Bandhu Ghosh. And as it was a judgment delivered in the year 1985, and it was also relating to termination of services on the basis of Regulation 34 of West Bengal State Electricity Board regulations, and also violation of Article 14 of the Constitution. So the Supreme Court bench consisting Justice Chinnappa O. Reddy, Justice E.S. Venkat Ramaya, and Justice R.V. Misra. So they let the judgment show in particularly as it is relating to West Bengal State Electricity Board Regulation 34 regulation confers full power on the employer to terminate services of permanent employees by serving 3 months' notice or salary. And therefore, no guidelines provided for the exercise of such power. So the regulation was held as arbitrary, and it was in violation of Article 14 of the Constitution of India. So the very first paragraph of the regulation that we would like to discuss here, Regulation 34 of the West Bengal State Electricity Board Regulations of 1952, which provides that in case of a permanent employee, his services may be terminated by serving 3 months' notice or an payment of salary for the corresponding period in lieu thereof. The Secretary of the Appellant Board terminated the services of the first respondent here, and that was this Bandhu Ghosh, a permanent employee with immediate effect on payment of 3 months' salary in lieu of 3 months' notice without giving any reasons as provided under Regulation 34 of the West Bengal State Electricity Board's regulations. There was nothing in order which could possibly be said to attach any stigma to the respondent. So the respondent filed a writ petition in the High Court of West Bengal, Calcutta, for quashing the imposed order. The High Court of Calcutta came to the conclusion that Regulation 34 was arbitrary in nature and suffered from the vice of enabling discrimination, and therefore it struck down the first paragraph of Regulation 34 of the West Bengal State Electricity Board regulations. As a consequence, quashed the order terminating the services of the first respondent in an appeal to this court, that is the Supreme Court. The appellant contended that Section 18A and 19 of the Electricity Supply Act laid down sufficient guidelines for the exercise of the power under Regulation 34, and in any case, The power to terminate the services of a permanent employee was vested in higher ranking officials and might be expected to be exercised in a reasonable way, and therefore regulation 34 of the West Bengal state electricity board regulations did not offend. So now the very question arises before the apex court regarding Article 14 of the Constitution, which clearly provides right to equality and equal protection of law. So, the Constitution bench in 1985 dismissing the appeal as it was filed by the West Bengal State Electricity Board held Article 14 has been interpreted in several decisions of the court and confinement and exercise of arbitrary power and on and by the state or its instrumentalities have been frowned upon and struck down by this apex court as offending Article 14 of the Constitution of India. So, in this present instance case, that is West Bengal State Electricity Board vs.Desh Bandhu Ghosh, on the face of its, the regulation is totally arbitrary and confers on the board a power which is capable of vicious discrimination. And it is a naked hair and fire rule, the time for banishing which altogether from employer employee relationship is fast approaching. Its only parallel is to be found in the NRE 8 clause, so familiar to administrative lawyers. So, in this context, as the apex court made reference to Workman Hindustan Steel Limited versus Hindustan Steel Limited, which was decided by the apex court in the year 1984, so also they made reference to another important landmark judgment delivered in the year 1964 by the apex court in Motiram Das Deka versus Northeast Frontier Railways. So now we will discuss about the very judgment delivered in this landmark case. So, while delivering the judgment, it was held that appellate jurisdiction and that was relating to the civil appeal number 562 of the year 1984 85 from the judgment and order dated exactly on 28 January 1985 of the Calcutta High Court in FMAT number 970 of 1984. So, here expressly from the bench, Justice Chinnappa Reddy takes the views that special leave granted the West Bengal State Electricity Board is the principal appellant in this appeal by special leave which, as per the judgment of the bench, have just now granted the first respondent, and that was Bandhu Ghosh. A permanent employee of the West Bengal State Electricity Board filed the writ petition out of which the appeal arises in the Calcutta High Court to squash an order dated back to 1984 of the Secretary of West Bengal State Electricity Board terminating his services as Deputy Secretary with immediate effect on payment of 3 months' salary in lieu of 3 months' notice. The order gave no reason for terminating the services of the respondent, and that was Bandhu Ghosh. And there was nothing in the order which could possibly be said to attach any stigma to the respondent. Apparently, the order was made under Regulation 34 of the West Bengal State Electricity Board Regulations of 1952, which enables the board to terminate the services of any permanent employee by serving 3 months' notice or an on payment of salary for the corresponding period in lieu thereof. So the High Court contrasted Regulation 34 with Regulation 33, which provides for the termination of services of both permanent and temporary employees of the West Bengal State Electricity Board on attaining the age of superannuation as a result of the disciplinary action and other provisions of the regulation for the sake of convenience. The bench extracted below Regulation 33 and the first paragraph, which alone is relevant, of Regulation 34. And as regarding Regulation 33, Clause 1, which provides, unless otherwise specified in the appointment order in any particular case, the services of a permanent employee of the board may be terminated. So, also, another important side of the judgment was delivered as regarding this judgment that without notice on his attaining the age of retirement regarding this Bandhu Ghosh, or by reason of a declaration by the competent medical authority that he is unfit for further service, or as a result of disciplinary action, or if he remains absent from duty on leave or otherwise for a continuous period exceeding 2 years. Further, in the case of a temporary employee, the services may be terminated by serving of either 1 month's notice on other side or on payment of a month's salary in lieu thereof, or notice on either side for the period specified in the appointment order or contract, or on payment of salary in lieu thereof, as the case may be. Further, the service of a temporary employee shall also be deemed to have been terminated automatically if the period of extraordinary leave without pay under or of unauthorized absence from duties exceeding a maximum period of 19 days In case of permanent employees, services may be terminated by serving 3 months' notice or on payment of salary for the corresponding period in lieu thereof. Contrasting Regulation 33 and 34 of the West Bengal State Electricity Board regulations of 1952, the Calcutta High Court came to the conclusion that Regulation 34 was arbitrary in nature and suffered from the vice of enabling discrimination. Further, the Calcutta High Court therefore struck down the first paragraph of Regulation 34 and as a consequence quashed the order terminating the services of Desh Bandhu Ghosh, the first respondent. The learned counsel for the West Bengal State Electricity Board submitted that Regulation 34 did not offend Article 14 of the Constitution of India, that Section 18A and 19 of the West Bengal State Electricity Board's regulation or the Electricity Act of the West Bengal State Electricity Board laid down sufficient guidelines for the exercise of the power under Regulation 34, and in any case, the power to terminate the services of a permanent employee was vested in higher ranking officials and might be expected to be exercised in a reasonable way, as it was held by the apex court by Justice R.B. Misra, as they were not impressed with the submission of the learned counsel for the West Bengal State Electricity Board. So, on the face of it, the regulation was totally arbitrary and confers on the board a power which is capable of vicious discrimination, and it was held a naked, fair and fair rule that the time for banishing which altogether from employer-employee relationship is fast approaching. It is only parallel is to be found in the Henry 8 clause, so familiar to administrative laws. Further, the bench of Justice Desai and Justice Chinappa Reddy held that as it was familiar to administrative lawyers in those cases like Motiram Dika vs. Northeast Frontier Railway, Rule 148 Clause 3 and Rule 149 Clause 3 of the Indian Railways Establishment Code were challenged on the ground that they were contrary to Article 311 Clause 2 of the Constitution of India. The challenge was upheld, though no opinion was expressed on the question whether the rule offended Article 14 of the Constitution of India. Since then, Article 14 has been interpreted in several decisions of the apex court, that is the Supreme Court, and conformant and exercise of arbitrary power on and by the state or its instrumentalities have been frowned upon and struck down by the apex court as offending. Article 14 of the Constitution of India, which particularly provided right to equality and equal protection of law. So, in this connection, the apex court made the reference that in S.S. Mule vs. J.R.D. Tata and P.V. Sawant, Justice of then the Bombay High Court, considered at great length the Regulation 48 Clause 1 of Air India Employees Service Regulations, which conferred similar power on the corporation, as it was decided by the apex court in the year 1964. Further, the apex court made reference to Regulation 48 and Regulation 34 of this present landmark judgment regarding West Bengal State Electricity Board. Regulation 34 confirms on the board in the present case. The learned judge struck down Regulation 48 Clause A. So, finally, the bench agreed with the reasoning and conclusion regarding the judgment delivered in Workman Hindustan Steel Limited versus Hindustan Steel Limited, where the apex court had occasion to hold that a standing order which conferred such arbitrary, uncanalized, and drastic power to enable the employer to dispense with an inquiry and to dismiss an employee without assigning any reason by merely stating that it was expedient and against the interest of the security to continue to employ the workman was violative of the basic requirement of the principle of natural justice. So, in this present important landmark judgment, the learned counsel for the appellant has relied upon the decision of Manohar P. Kharkar versus Rauras to contend that Regulation 48 Regulation 48 of the Air India Employees Serving Regulation was valid. It is difficult to agree with the reasoning of the Delhi High Court that because of the complexities of modern administration and the unpredictable exigencies arising in the course of such administration, it is necessary for an employer to be vested with such powers as those under Regulation 48. So, accordingly, the bench referred the reasoning of Justice Sawant of the Bombay High Court and that of the Calcutta High Court on the judgment under the appeal to reasoning of the Delhi High Court. So, finally, as the judgment. The appeal filed by the West Bengal State Electricity Board was dismissed by the apex court with costs. So hereby we complete another most important landmark judgment delivered in the year 1985 relating to termination of services of permanent employees. So, in that connection, we have discussed the very regulation 34 of the West Bengal State Electricity Board regulations, and also we have discussed the regulations made regarding Air India, and finally we have touched the very provisions of Article 14 of the Constitution of India. So also the very provisions laid down under those different regulations either made by the West Bengal State Electricity Board regulation of 1952 and the Air India regulations. So hereby we conclude our valuable lecture discussing on the aspects of termination of services of permanent employees and their dismissal or reduction in rank and dismissal from services.